one more fun guest for you. As always, I'm Josh Constantinou, the Coordinated Access Coordinator for the John Howard Society. And we've had a bit of a mixture of folks this week. We haven't had just yourself as the steady co-host, but welcome back there, Conor.
Thanks, Josh. Great to be back. Hi, everyone. This is Conor Mullin, president of the John Howard Society of PEI. Glad to be back on the podcast for the first time since January. And glad to be here to celebrate the end of John Howard Society Week 2025.
All right. And now we'll turn it over to Professor Susan Bandy, sorry. Susan, thanks again for agreeing to join us here today. We're excited to jump in, but before we do, why don't you tell us a little bit about yourself?
Hi, thanks so much for having me. I'm excited to be here. I am a professor of law, and before that, I practiced law for a number of years, doing civil rights law, and also prior to that, criminal defense, on appellate defense. And when I started teaching, I guess the way I describe it is I was still drinking the Kool-Aid in those early days and thinking that somehow emotion and rationality were opposing forces, and that to be a good lawyer, you could not be emotional. You had to put your emotions aside, in that famous phrase. And a few years down the road, I started questioning that. And I could get more deeply into what caused me to question it. But I think, for the purposes of what we're doing today, we can maybe do that later. We'll see. But I was starting to rethink some of my own experience as a criminal lawyer, as a lawyer who represented, a whole range of people, and the role of the victim in the criminal justice system, and a whole lot of other issues, and just became convinced that the legal system was just suffused with emotion, and that because we continued to ignore, or more than just ignore, really deny the role of emotion and the existence of emotion, what we're really doing is cutting ourselves off from some really important sources of information about human behavior. And to oversimplify things a bit, I would say that the criminal justice system is a vast system for channeling and educating and trying to predict human behavior. So the idea of trying to do that without using what all these other fields know about emotion ultimately seemed kind of self-defeating to me. So that's the big picture. As to the picture that we're talking about today, the topic of remorse, we could talk about that anytime you're ready. But that's my general introduction, and we can take it from there.
Fantastic. Yeah, no, that's it's neat to hear sort of how you had that light bulb moment, if you will, where you started to think, hey, why are these two so disconnected and like you said, opposing when they work so closely together?
Yeah. So I'd be interested to hear a little bit more about that. So just kind of for your information and for anyone listening, I am a criminal defense lawyer. And so I often do find myself in that same mode that you're talking about, of trying to engage sort of the rationality while keeping emotion out of it. So I'd be very interested in hearing about what was the kind of the reason or the moment that led to you to realize, hey, that's maybe not serving the interest of justice in the best way.
Sure. Yeah. I there are a couple of moments. Years later, the nice thing about being an academic is you get to sit back a little, away from the pressure of everyday cases, and have a little bit of time to piece together what you've been going through. And one thing that I remembered was, being very outraged by a case in my first week of law school, being very outraged by the outcome of a case. And I remember writing in the margin of my book, well, I can't use the word on on radio, but I wrote a rather I wrote a rather frustrated little note in my margins that basically that this is a horrible result with an exclamation point. And I remember thinking, I can't say that out loud. If I say that out loud, then people will think I'm not thinking like a lawyer. And I went back to that later and thought, well, how did I learn so early, or mislearn, you might say, so early, that moral outrage is somehow irrelevant to lawyer-like analysis? And it took me a long time to sort of circle back and think about how wrong that was, and how, in a sense, outrage is one of the things that really propelled me to become a lawyer and to be a lawyer, and really drew me to every topic I ever wrote about. And then since you are a criminal lawyer, well, Canada, like the United States, uses victim impact statements. Am I right?
You are right. Yep.
And every common law country does at this point. So a few years into my teaching, there were two cases decided within a year of each other by the United States Supreme Court. And the first one was the case of Joshua Constantinou, who was a little boy who had been beaten by his dad pretty much constantly. And he was on the radar of the Wisconsin Department of Social Services, which basically thoroughly dropped the ball. And he was finally beaten so badly that he was institutionalized for the rest of his life and died in his 30s. And the question was whether there was a constitutional duty to protect him. And what was fascinating about that opinion, and a lot of people feel like it was one of the canonical opinions that really started people, at least around here, on thinking about the role of emotion in law. The court said, we feel terrible for Joshua, like any human being was. They actually went out of their way to say judges are human. But nevertheless, our job is to put that compassion away and aside and decide just on the law. And I read that and I thought, and it didn't immediately strike me as wrong. As I said, I think I was still drinking the Kool-Aid at that point. And then a year later, the Payne versus Tennessee, which is the Supreme Court case upholding the use of victim impact statements in capital cases. And of course, in the US here, we have the great shame of still having capital punishment. And there the court said that people who had lost someone to murder were able to get up in a victim impact statement, and even though it wasn't germane to the actual facts of the case, talk about how the crime had made them feel and about the particular characteristics of the person they had lost, and why it was such a devastating loss. And then I became thoroughly confused. And then I thought, I don't understand this. I thought the court said last year that compassion and empathy were irrelevant, and now they're creating a whole new vehicle for allowing it into the courtroom. What's going on here? And I thought to myself, I'll just spend an hour or two getting on Westlaw, legal search engine, and researching the role of compassion in law. And I really thought that there would be an answer out there. So the tagline is, here I am, I guess 30 years later, still trying to figure it out.
Yeah, that is an interesting point on the uses of emotion. I mean, quite often judges will say, at least when it comes to making decisions, that emotion has to be put aside. And in jury trials, juries are instructed that they have to put their emotions and their beliefs and their preconceived notions and everything aside when it comes to deciding a case. Which I think in a lot of ways does make sense. You sort of want a dispassionate observer, maybe. Although I'd certainly be interested to hear if you have a different opinion. But then when it comes to sentencing, we have this sort of window then where we do let that sense of outrage or loss or whatever it is kind of fuel or dictate what is an appropriate sentence and to a certain extent. And so yeah, it's a bit of an interesting kind of contradiction and dichotomy there. So yeah, you're quite right.
Yeah, and I think, I would like to get more specific about remorse now because I think it'll be helpful to people. But I just want to say that I wouldn't want to leave the impression that all the emotion is in sentencing and not during the trial. The way that if we do start taking seriously what psychology and sociology and neuroscience and all these others domains have learned about the reasoning process, we see that emotion is always part of the reasoning process. Just as a quick example, in the way that we tell stories, not just to juries, but to judges, for example, people learn what the law is and how to apply it by using empathy and by imagining stories. They don't just reason algorithmically or whatever the right word is. So I would just say it's very pervasive, and the idea is to sort out when it helps and when it hurts, and how we can fix things when it hurts. And so I think remorse became so important to my analysis because, in a way, it's really the poster child for what goes wrong when you don't acknowledge emotion. And I can go further into that if you guys are ready to.
Yeah, please.
Yeah, please do.
Okay, so people often ask me, by the way, when they hear what I do, why I want to bring emotion into the criminal justice system. And I always say, I don't. It's there already. I did not put it there. I just want to acknowledge that it's there, and I want to evaluate how it's affecting the criminal justice system or the justice system more generally, and not ignore it. And remorse is the example of what goes wrong when we ignore emotion. So I'll start with an example from the US, even though the death penalty doesn't apply in Canada, but certainly remorse is pervasive, or these feelings of remorse are pervasive even without the death penalty. But I want to start with this example because we have so much empirical data on it. So I think it makes a really compelling story. In the US, the Capital Jury Project has interviewed thousands of jurors who had actually served on capital cases and asked them what was important to them in their decision. And they found that either one of the three most important factors or the most important factor in many cases in the eyes of a jury in deciding whether to sentence the defendant to death or not was whether the defendant appeared remorseful. And the important thing to add here to make this understandable is that in capital cases, for various reasons, criminal defendants almost never testify. They have the right to, obviously, but they almost never do. So when the jury says that it has determined that the defendant wasn't remorseful or was remorseful, which is much more rare, what they mean is that they were watching the defendant sit silently in the courtroom as the defendant himself was watching the evidence unfold, looking at the face of the defendant, and then retiring to the jury room. Nobody instructed them about remorse. The judge never mentioned it to them in their instructions. And often the first thing they talk about, and often the thing they talk about vastly more than any other topic, is whether the defendant was remorseful. And so what they're doing is they're reading, or thinking they're reading, his facial expression and body language to determine whether he's remorseful. And their conclusion on that is often the deciding factor in whether they sentence him to death or not. So that's a situation in which we have the evidence. And it's a situation in which they are not getting, that they are relying on what I will call their folk knowledge, right? They are going into the jury room and consulting what they all believe. And they all believe that two important things. A, that remorse matters hugely, and B, that they are capable of evaluating it. So that's the setting that really drew me into this. I found it quite shocking. And in non-capital cases, the difference in the U.S., and I believe this is also true in the Canadian system, is that judges do the sentencing. Am I right about that? Yeah, okay.
Correct, yes.
Okay, so you might be tempted to say, oh, well, of course, juries, they're lay people, they don't know any better. But there have been a number of studies of judges and in both countries. And judges also harbor the same belief, actually both beliefs, that remorse matters greatly and that they are able to determine it from body language and facial expression. Now, of course, judges are in a slightly different position because they get to talk to the defendant. So you might be tempted to say, well, they're in a better position because they get the defendant's words, they get to know the defendant a little. But here's where the studies are really interesting, and you can help me figure out what direction you want to go in from here, but I'll just lay out the problem. Judges also harbor these very unrealistic beliefs about what you can tell from body language and facial expression, and they believe, as juries do, that facial expression is a more reliable way of determining remorse than words, because they believe that words can be faked and that facial expression cannot. And if you press them on why it should matter, you start seeing what the problem is. There's no good evidence as to why remorse actually should matter. I'll just say one more thing, and then I'd like you to let me know what direction you want to go in. Judges and juries both believe that a remorseful person, assuming you could tell who was remorseful, is less likely to recidivate, or to use a less to use common language, is less likely to commit another crime. Right? There's no evidence whatsoever for that proposition.
Susan, I just want a point of clarification, just because we don't have capital punishment in Canada. So when you're talking about these capital cases where the jurors are making this decision, is that following a trial on guilt or innocence, or is that just related to the sentence?
Thanks for asking that. Yeah, I should have clarified that earlier. The way it works here is that we have a trial phase, which is the guilt or innocence phase, and then we have the penalty phase. And in the United States, a jury decides the sentence in every death penalty case. So it's the same jury that does both. The jury first decides whether the defendant is guilty or innocent, and then assuming it's a capital crime, a crime that could be eligible for the death penalty, and then they will decide whether to sentence him to death or to life in prison.
So then part of that, the sort of the one thing that strikes me there is how the importance of remorse could undermine the presumption of innocence. Because I'm thinking, if somebody, and I'm curious what you think as somebody who used to do a lot of criminal appellate work. If somebody, wants to maintain their innocence, or maybe is actually innocent and so can't express remorse, are they then more likely to be sentenced to death? So is there a problem there where innocent people could be more likely to be sentenced to death because they're not remorseful for not having done anything?
You're right on the money there. That's absolutely right. It's a huge problem. So I was, a million cases have just crowded into my mind, but this happens quite frequently. Of course, at the guilt or innocence phase, at the trial, as we might just want to call it at this point, you shouldn't really be thinking about remorse, right? Strictly speaking, but there's a case, for example, that I'm writing a book. I can tell you more about it later. But I just wrote the chapter on remorse, and I was digging deeply into the Scott Peterson case that was a big deal over here in California of a man whose wife and unborn child drowned. And at the trial, he was being vilified for looking unremorseful. This is, of course, at the point where he still has, as you point out, the presumption of innocence. But the jury was so upset by the horrific nature of the crime, the fact that this in utero baby died, and et cetera, and his calm demeanor just really upset them. And there's lots of evidence in the transcript that they turned against him because he just didn't look remorseful or appropriately emotional for this crime that he hadn't yet been convicted of. And then they did convict him, partly on that evidence. And then they sentenced him to death for the same reason, because he just had such a sort of affectless look to him. So innocence becomes a huge problem, and it's a problem at sentencing. It's even a problem at trial, as in the example I just gave. And then once somebody is sentenced to prison, at least in the US, a lot of programs hinge access to programs, and I just blanked on the name of somebody who I wanted to mention to you, but it'll come back to me. But the ability to get into programs that might shorten your sentence later might hinge on your willingness to accept responsibility. A lot of people are shut out of prison programs as they want to accept responsibility. So this also, again, is another double whammy for people who are actually innocent. So that's a huge problem. And other problems with the ability to read facial expression are race, ethnicity, being a juvenile, having various mental disabilities or mental illnesses. There are lots of factors that interfere with the ability to tell whether someone's remorseful. But I'll go a step further than that and say, even for someone who hasn't got any of those additional factors, it's just a misnomer. It's just a fallacy to believe that it's possible to tell somebody's remorse or lack of remorse by looking at their face during the brief time slice of a trial or a sentencing hearing.
Yeah, I don't know if you're familiar. There's one of the sort of most famous miscarriages of justice in Canada was an Indigenous guy by the name of Donald Marshall Jr., who was convicted of murder. And part of the reason they did is that he was, it's somewhat related to what you're talking about with remorse, but it was felt he wasn't being truthful on the stand because he didn't look people in the eye, and just his general demeanor. He was eventually exonerated on appeal and released from jail after having spent like decades in prison. And it was determined that a lot of those factors were cultural as an Indigenous person, where for him it was disrespectful to look people in the eye and things of that nature.
Precisely. That's exactly right. Yeah. And I don't know if it was that case, but I talk about a quote from one Canadian judge who says that after years, he finally realized that he was misreading that cultural cue in cases with Indigenous defendants, and that, of course, there are many cultures that have these that have varying cultural cues and beliefs about whether it's respectful or disrespectful to look someone in the eye. There was an American study in Connecticut of 20 judges where the judges were asked whether they thought they could tell remorse from facial expression, and most of the judges said they could do it. And then they asked them to detail what it was that they thought indicated remorse or lack of remorse. And about literally down the middle, half of them said eye contact was a sign of remorse and, as you say, trustworthiness. This is not only about remorse. This is about, is this a person we can believe, is this a credible person? Half said direct eye contact was a sign of that, and the other half said that direct contact from a defendant was disrespectful and that they would find that person remorseless. So they were absolutely split down the middle on that.
So pivoting to kind of another aspect of remorse there, Susan, how is there any studies that you've either done or that you're aware of that show how victims feel about accused, like convicted or otherwise, expressing remorse, or what they feel is remorse?
Well, I don't know if a direct study on that, but I've done a lot of reading about what makes victims feel, or victims or people who have lost someone to murder, what makes them feel satisfied with the criminal justice system. And I have a lot of worries. I've written about closure, for example, on this, in my opinion, very misguided notion that a criminal proceeding can give somebody some kind of emotional closure. I think that a lot of people have a sort of Hallmark card moment that has been transmitted to them, that somehow things will play out in a certain very idealized way, that the defendant will somehow express visible remorse, and this will somehow help the person make sense of the loss, the injury or the loss, and maybe even take a step to forgive them. There are a couple of articles written by colleagues in the United States that sort of lay this out as a kind of ideal. It doesn't generally happen that way, partly because the system is just not set up for that. My own thought is that a better option, and I'm certainly not saying a perfect option, but a better option for that kind of interchange is victim offender mediation, because in a regular adversarial criminal courtroom, it's very difficult. There's not a lot of room for showing genuine emotion for anybody, really. And what I prefer about victim offender mediation is that in a situation like that, the participants are screened in advance to see whether they really understand what might happen and what could go wrong and what the limits are of the emotions that can be shown. And then this is also mediated by trained personnel who know something about how emotion does play out. In a regular courtroom, there are no people who are trained in how these emotions play out. So you send a victim into a courtroom. We're having a situation like that right here in Illinois this week with somebody who performed a mass shooting in Highland Park, Illinois, a suburb of Chicago. And the victim's really hoping to see something in his face that will help them make sense of the crime. But that's generally a vain hope, not because of however it is that the defendant feels, but because there's just not really room for that kind of genuine interchange. So I worry that people will get doubly victimized if they walk in with those sorts of unrealistic expectations.
Yeah, we have a similar process here in Canada. I think we refer to it as restorative justice, but I have seen a number of I have seen a number of talks from people who have participated in that, like you say, like people who have lost loved ones to murder, and they almost, when it's been a successful process and gone through all those steps, like you say, with proper screening and preparation on both sides, they generally come out of it really feeling quite good about the process.
Mm-hmm, exactly. Yeah, and as I say, I don't mean to imply that it's a perfect process. I know that, there are critiques of it, but it's certainly much better targeted toward the kinds of exchanges, if they're genuine, I don't know, but they're certainly more genuine and more able to be genuine than can occur in a criminal courtroom, where we are basically asking judges who have absolutely no training in this to mediate some very powerful emotions. And I think part of the bottom line here is that if we do want the criminal process to be in some way therapeutic, we haven't really done the work to make that happen.
And just again, curious because we don't have capital punishment in Canada. Is there any studies or anything that you're aware of that talk about, like, is there any sense of kind of closure or relief for the loved ones of victims in murders if the accused person is sentenced to death?
There are a couple of studies, and I just actually am working on my closure chapter for my book right now. Trying to think about how much detail I want to go in here. I think the bottom line I would say here is the whole notion of closure is a really odd kind of notion. When I first heard about closure in the the late 1980s, I assumed, as everyone else did, that it must be some kind of a long-standing psychological emotion. And when I started researching it, this turned out not to be the case at all. In psychology, the word closure comes up, but it's not. It doesn't mean what we in criminal justice might think it means. There's something called a need for closure, which basically refers to the need that some people have for everything to be unambiguous and settled. It's not necessarily thought of as a good thing. It's, people that can't handle ambiguity have a heightened need for closure. So somehow there is no such thing as closure in the way we're using it in psychology. This is a term that took root during the victims' rights era in the late 1980s, and it's not a psychological term. It's really more of a goal of the victims' rights system to have people be able to give victim impact statements and do a number of other things, many of which are very, very important, like participate, in ways that give them some sense of control and learn what's happening and being kept in the loop. But the leap from that to the idea that you will get some kind of emotional closure is a big leap, let's say. There's the studies do not show that. Well, there's one important study that compares a death penalty state to a non-death penalty state in the United States. And what it basically showed was that the people from the non-death penalty state were doing better than the people from the death penalty state. The victims or the families of victims were doing better because they weren't mired in this. I don't know how to put it. Just say the criminal justice system wasn't necessarily helping them, and they were able to move on from it better. If you tell people the law will take your law seriously and will do something for it, that's important. But if you tell people only the ultimate punishment will help you, and the ultimate punishment is death, that raises a whole host of problems.
Yeah, I can imagine. Yeah, I'm very grateful that we no longer have that option in Canada.
I am so envious, I can't even tell you. But so in both these cases, really, closure and remorse, I think we're dealing with the same thing, which is, and let me go back again and remind you of the sort of question that I often get: why do I want to bring emotion into the criminal justice system? And my response, again, I did not bring closure into the criminal justice system. I did not bring remorse into the criminal justice system or victim impact statements. All of these things were imported into the criminal justice system without sufficient study of whether they would advance the appropriate and worthy goals of that system, or whether they would perhaps be completely counter to those goals. And so what I advocate is kind of the process that I was just outlining for you. Other psychology and other fields look into what the emotions are and how they actually work, how their dynamics work. We find that telling people that they're going to attain closure if they hold out for for a death sentence in the United States, or for the most punitive sentence possible in other places, that turns out not to really be very helpful, not to be very healing. So if what we really want is to help victims heal, then maybe we shouldn't be doing that. And likewise, if it turns out remorse isn't really working well as a factor, partly because we can't reliably identify it in a courtroom or a jury room, and partly because it doesn't do what we think it ought to do. It doesn't separate out people who are going to recidivate from those who are not. Then maybe we should take those things seriously and thinking about whether these are the right emotions or not. And once we do that, we can think about solutions. And so for remorse, for example, there are a number of things we could do. We could instruct juries. We could train judges about what we do and don't know about remorse. We can train judges about how there might be different cultural assumptions about facial expression, body language. We could take remorse out of the criminal code in the few places that it's mentioned, and it isn't mentioned very often. But we could instruct people that a failure to testify shouldn't be taken as a lack of remorse, et cetera, et cetera. So the point is, once we identify how these emotions are working, and we have to do this by looking to fields that have actually studied them, then we can actually think about whether they align with what we're trying to achieve here.
And as you talk about sort of this idea of the criminal justice system accepting that these emotions are already in play and how they have an impact, what do you find in terms of your work or the work of colleagues is the response from the criminal justice system, or where are they at in terms of their willingness to accept the roles of remorse and emotion and the impact they have?
It's tough. It is very tough. I think one of there are a number of things I'm finding. I mean, on the most abstract, basic level, I think that my references to drinking the Kool-Aid, the Kool-Aid is still being widely consumed. It is very hard to convince lawyers that, or the legal system, I shouldn't say lawyers, but the legal system as a system, that emotion is not some kind of weakness, that it's part of how we make decisions. And by ignoring part of how we make decisions, we are just hurting ourselves. It's very ingrained. So that's difficult. But let me give you a more practical example. This kind of folk knowledge that I referred to earlier, like when a jury that has not been instructed about remorse thinks they know about remorse and does this on their own in the jury room, but we have empirical evidence. They do it over and over again, right? They say, let's talk about remorse. It's really important, and we have the ability to evaluate it. We just ignored that. But when you try to get expert testimony about something like that, a lot of courts respond by saying they don't want it mentioned. Their attitude is, if nobody's mentioned it to the jury, then the jury won't think about it. And your response is, well, but we have empirical evidence that they do think about it. But this idea that people walk into the jury room or ascend to the bench, if you're a judge, with a whole host of assumptions about emotion, is very hard to communicate.
Right. Yeah. Say maybe, the biggest thing we need to do now is sort of tear down this legal fiction we tell each other or tell ourselves or each other, that judges, lawyers, whatever, that we're sort of above all that, dispassionate observers, advocates, whatever, and recognize that, as you mentioned a couple times, we're all human and we all have these emotions, preconceived ideas, whatever, that they exist, they're there, and we need to find a way to deal with them within this system that wants to also pretend that they don't exist or play a role.
Exactly. Very well put. exactly right.
So we're moving towards the end of our time here, Susan, and I think we've had some great conversations and discussions. Before
I
we
really enjoyed it. Yeah.
thank you. Before we move to sort of closing things up, is there anything else that we didn't get to touch on that you wanted to share with us?
Oh, well, do you mind if I mention my book?
Sure, yeah, we can go there too. Yeah, of course.
Or okay. Did you have something else in mind?
No, I was just making sure there wasn't any sort of content related things before we.
Oh, content related. Okay.
What you're working on.
I know. Let's hear about the book.
Yeah, let's do it.
Yeah. Okay. Well. Okay. Well. So. Well. First of all, this all began 2 decades ago, or more than that, actually, at this point, with a book called "The Passions of Law," which I edited for NYU Press, and that was the book. That was not specifically related to criminal law, but that was the book that a lot of people, I say with a little bit of a blush, have said really set off this entire field. So I'm very proud to brag about that. But I finally now am at the point where I really want to write my own monographs, pulling together a lot of what I think I know, and it will be focused on criminal justice. And the book is called "The Myth of Pure Reason: How Ignoring Emotion Derails Criminal Justice." At least
I like
that's
the title.
Thank you. That's the working title. I'm glad you like it. Thank you. And it's under contract with Yale University Press, and I'm still writing it, but I'm very excited about it. And I'm just pulling together my decades of thought about all these topics: remorse and closure and victim impact statements, and the role of empathy in judging, and moral outrage, and et cetera, et cetera.
That's fantastic.
And when any idea when that's going to be out?
Well, it will be finished in 1 year from now, and then I think it probably does take about another several months or so to get it out. So unfortunately, we're probably looking at a year and a half or 2 years here.
All right. Well, everybody listening, add that to your to be read list. Keep an eye out for it.
Is there anything else you're working on, or do you want to share where people can find you or your research or books?
Oh, absolutely. So I do have a website, which is susanbandes.com, SUSANBANDES. Let me make sure that I gave you the right website here. And I just want to make sure I didn't use my middle initial. Yeah, SusanBandes.com. Yeah, and at that website, I have lots and lots of information about law and emotion in general, including my own various interviews and my articles and my book and et cetera, et cetera. So if people want to learn more, not just about me, but more important about law and emotion as a field in general, that would be one good place to take a look.
Perfect. And every time we post the podcast on our website, we also put a link to the person's website. So we'll make sure that yours is on there underneath the podcast episode.
Wonderful. Well, thank you. I've really enjoyed this opportunity to talk with you guys about my work and about these issues.
Thank you.
Yeah, no, thank you. It was a great conversation, very interesting, and I look forward to your book coming out.
Thank you very much.
So we'll wrap up with our John Howard Week sign off here. We've reached the end of what's been another awesome week. Lots of great guests we had a chance to chat with, including Susan, of course. Please check out the John Howard Society of PEI YouTube channel and our website and social media. We will be back in April with our monthly podcast and potentially continuing this theme of getting an international perspective on criminal justice and other related subjects. With some potential guests that are also in other parts of the world. Conor, anything you wanted to share if we're
No, please everyone just check out our YouTube page, John Howard Society PEI. Check us out online, johnhowardsocietypei.com. Find us on Facebook. Like and subscribe, please. Helps us out a lot to get the word out about all the work that we're doing. If anyone's interested in the work that the John Howard Society of PEI does, you can check out our website, call the office, speak to any of our staff. If you're interested in volunteering, if you're interested in joining the board of directors, links to all that can be found online. And please reach out with any questions, inquiries, interests that you have. We're always happy to hear from members of the public.
For sure. Well put. All right. Thanks again, Susan. We really appreciate your time, and thanks for joining our podcast.
Yeah, thanks
My
a lot.
pleasure. Thanks again for having me.
Yes, thanks, Susan. That's a great way to end off John Howard Week.
Bye.
Take care.